on digital markets regulations as well, and just cross-border competition matters. He supports both public and private institutions through ongoing training and capacity building initiatives, and has led teams in landmark work, including the high-profile digital market regulation litigation matters before the Competition Tribunal, M&A transactions, and just competition law market studies, including one that recently concluded for the Ministry of Communications and Digital Economy in Nigeria. And so without further ado, I would like us to, ladies and gentlemen, to please join me in welcoming Ikem Isiakwena to facilitate this session for the next about 90 minutes before we move into our Q&A session. So Ikem, the floor is yours. Please just remember that you can ask your questions and put them in the Q&A box, and we'll address those later. So thank you so much once again for joining us. We hope that this session is insightful for everybody who has joined. So thank you so much once again. Ikem, please go ahead.
Yeah, thank you so much, Dara. Please just confirm that you can see my screen.
Yes, we can see your screen.
Okay, so we will dive right into it. So as they would say, all protocols duly observed. I know I have my learned senior colleagues who have also joined the call, and to my esteemed colleagues as well. I want to thank everyone for joining today's session. What we're going to be doing is simply just whetting your appetite to understand what this aspect of legal practice entails, on a whole, and also just understanding the sort of discipline that is required for mastery. So I am going to, just go through a sort of storytelling arc to make the point. So I have this laid out in 3 acts, and my first set of stories will be in our Act 1 aspect. So Act 1 is titled of Folly and Fortune. So the gentleman on the screen is Ade, is an idealist. So he's gone to court advising his clients, to strike down certain sections of the Federal Competition and Consumer Protection Act. And his basis for this is that it is unconstitutional. The commission is not a court. The commission cannot convict, so they can't administer penalties as such. The entire thing is void because obviously it's implacable when you put it side by side with Section 36. Very astute lawyerly argument. Now, the hero who thinks he's saving the village here is only leaving everyone exposed to an unchecked market forces. That's sort of baseline number 1. You think you're a hero because you're making this very sort of nice sounding constitutional argument. And so we have a familiar scene playing out because he's actually chopping the branch that sustains him. So you celebrate a technical win. Yes, the court agrees that this thing is, you can't establish fines, as a regulator. You would need to go to court. So indeed, every administrative authority in the entire nation would have to have a criminal conviction before you can have a sort of orderly existence. And if you check what that has to, the sort of consequences for, just daily living, our airspace, our monetary policies, administrative authorities cannot act quickly because there's an argument about conviction before, and it's only courts that can do this. So that's, a short-term win, but there's a long-term loss for the profession and the market. And how is this? The aftermath is very bleak. If a court actually heard that that's true, so the commission cannot investigate, so there are no more probes, then there's no more strategic advisory work. So the demand for competition law experts, it plummets. And so the complexity that lawyers are meant to advise on and navigate, it disappears, just with this one argument. But Ade has earned a fee of 10 million naira, but it earned that years ago and is not going to earn any additional fees. So that's exactly what we're looking at, a short-term win in this act, in this scene. And scene two is titled The Spicy Gold Mine and the Legislative Blindside. So our second protagonist is BC. He confidently thinks that the FCCP, as a regulator, engages in constitutional overreach. So he advises, the National Assembly, strip those powers. Only the courts should decide, about, if someone should be fined, a financial institution should be fined or not. And so he also argues before the monetary regulator, and he says that, let's carve out the financial sector away. Let the Central Bank of Zamunda, and this is our sort of hypothetical nation, the Central Bank of Zamunda should, in addition to dealing with monetary policy, issuing currency, and those sort of very specialist technical things, it should also do competition policy and consumer protection work. So he champions proposals that this needs bureaucratic streamlining. So obviously you can recognize the bold rhetoric when you say it, but what it does fundamentally is that we have a path that weakens your competition law institutions, and it also confuses the market. So what are the consequences? So let's assume in a world in Zamunda, in a hypothetical country, these amendments, they pass. So key aspects of the law are weakened. The financial sector, financial institutions, and banks are carved out. They don't have to, go through any sort of assessment for competition law and consumer protection sort of protections. And so what we find is in the marketplace, concentration could actually surge, right? A market disorder could actually follow. Then for the practice, for legal practice, so demand for genuine competition law expertise from 2018, rather than it continue to grow, plummets, because everything that would happen in that sector is taken out of the purview of competition law sort of expertise. So advisory work disappears. Clients would sort of migrate to firms with, things that can drive capacity. And it's very important to understand that. But if you look everywhere else, even on the planet, even on the continent in Africa, right? If you look at the practice in South Africa, you have a burgeoning and growing competition, very vibrant competition law practice. You have even smaller countries like Malawi, Zambia, and they have a vibrant competition law, practice. And we are like the biggest by GDP size, we are the biggest nation in Africa. And so it means that everything that you're going to have in terms of voluntary disclosures that will go to the competition authority, preventive counseling that lawyers will provide the banks and financial institutions, the sort of complex reviews that will generate sustained fees are, basically yanked off by this sort of, activities that I, can be rightly categorized as folly. So, short-term wins evidently would destroy this. And so for us, the analogy we use is the losing chef. So BC can be seen as the chef who complains that the spices that he uses in his kitchen are too spicy and too complex. And he insists that they be thrown out. And he forgets that the very flavor of the dish, your relevance as a chef, it depends on the complexity of your spices. So as the spices, which in this case is market complexity, investigations, merger reviews, advisory work on dominance, preventive work on cartels, as those things disappear in that sector, so does the work. So you can't bin all your spices and continue to be a chef. So that sort of, lays the background for a redemptive arc. And so my third scene is a redemptive story. So the once misguided lawyer, he changes course, he pivots, and he embraces the discipline. So you begin to advise the regulators, NERC, NUPRC, NCC, other regulators on sort of harmonizing your sectoral mandate with the competition regime and consumer protection regime. So you promote coordination and harmonization. So you have a booming cross-sector practice, steady advisory work, and renewed relevance that builds on what people categorize as complexities, but that we would see can actually be understood by everyone who has joined in on this webinar. So I just want you to picture, for you who are listening to me, your story tomorrow, that this is a path before you. So I am more on an indoctrination sort of mission today to convert as many people as possible to understand that competition law provides, a very useful opportunity, and it's not necessarily, it's not to impair businesses. Rather, it gives businesses a solid foundation to do business fairly. And we as lawyers, as far as economic justice is concerned, you cannot really be a champion of economic justice if you do not understand competition law. So what we are about to do is to arm you with the source and substance, and we're going to add some economics together. So let's dig in. So our Act 2 is the source and substance. Now, the best way to picture competition law, and I'm going to use some examples. You hear often, if you go back to your high school economics, secondary school, you hear about equilibrium. The equilibrium, what was it? It's simply balance, right? Now, there are two sides to a market. You have the supply side and you have the demand side. On the supply side, you have businesses. On the demand side, you have consumers and people who pay for those services or for those goods. Now, every day you wake up, I want you to think about how many products you've used today, just waking up and getting to work, being on this webinar. How many products have you used? I mean, I always make a joke that if you were to ask some of our, sort of like female colleagues, like just your upper cavity alone, your hair, and all the things that make you look very dazzling and beautiful around your face, your shirt, and all that stuff. You're part of this juggernaut of consumption that is happening. And so there are fundamental assumptions we have to take about the marketplace. Now, what society idealizes, what society expects is a balance. That day one, when I go to purchase this mug, right, that there is balance, there is fairness, and all that stuff, right? But that's not necessarily the case, right? And this is where we understand the forces of supply and demand. Now, on the one hand, what you have to understand is that when I go to buy this mug, right, I do not know what it is made of. The coffee in my cup, I believe the person who's selling it to me that it is actually coffee. So if I wanted decaf and he gave me something that was caffeinated, I will be acting on the assumption that the information that he has provided to me is accurate, complete, and all that stuff. But the producer has all that information. So the very first condition we find in the marketplace is asymmetric information. The guy who produces has all the information about what is produced, right? So the balance tilts in favor of the supply side because when you go purchase, you have absolutely no way of knowing except the law imposes an obligation on the supply side to provide accurate, complete information that is not misrepresented in any way, fashion, or form. So that's one thing about balance. What is the other thing that tilts this balance? And always think about this as a playground seesaw, that tool that is used by kids to sort of go up and down, and all. So the weight is firmly on the side of supply side. Second condition is unequal bargaining power. So, if you think about how a company would negotiate with a small supplier, say if you have a large store, a large departmental store, or a supermarket chain, they are able to squeeze the small farmer because the small farmer sells perishable goods and he has maybe a 3-day window to sell his produce, or he has a complete loss. So that creates certain power to act in a manner that is independent of the opposite side, right? So think about bargaining power. In every transaction, there is someone who has more leverage than the other. Now, in the simple transactional flow, the seller has more bargaining power. So that's a second point. Then the third point is also better resources. Think about all the products that you've used. So for me, my glasses, my wristwatch, the shirt I'm wearing, and if there is any defect with respect to any one of these things, right? What do I do? Am I going to hire a lawyer? Am I going to call some fancy lawyer in Simmons Cooper and say, listen, I've got an issue with my glasses and I want you to file an action, right? Whereas businesses are often more organized, they have legal departments so that would take into account all the sort of complaints that they will receive and they're able to address them on that aggregate basis. So businesses by nature have better resources. So that's condition number 3 that ensures that, or that makes it that you don't start out with equilibrium, when you're making or when you're doing that transaction. So what happens? How do you restore market justice? The Constitution provides us a veritable platform. So in the Constitution, we have what we call our chapter 2. So everyone here will probably understand that, chapter 2 rights or chapter 2 principles are non-justiciable. So it's what's called fundamental directives of state policy that provide guidance for all the organs of government, about how the nation will be shaped. So what are our economic objectives? Section 16 prohibits an economic system from being operated in a way that permits the concentration of wealth or the means of production in the hands of a few individuals or groups. So what's this? What does this mean? So it simply means that we want a free market economy. You want the factors of production, the means of production, which will be land, capital, right? I mean, the entrepreneur is somewhere in and labor, right? You don't want them to be concentrated in a manner that is not competitive. So what we are actually articulating in chapter 2 is that we want a free market enterprise that is competitive. And so you now have subsection 3 that actually mandates that a body will be established by an act of the National Assembly to review from time to time the ownership and control of business enterprises operating in Nigeria. I beg to say this is not a registry function, as the Corporate Affairs Commission will be. For the Corporate Affairs Commission, it is garbage in, garbage out. It is essentially a registry. So, but for a competition commission, in doing a merger review, for instance, what the commission is interested in is control. who controls the business making decision in these merging parties? And are they able to either by themselves unilaterally or in coordination with another party distort competition? So hence section 16 sub 3 provides for this body. Now, anyone will remember maybe what going to 30 years now, but certainly more than 20 years. So at the onset of the Fourth Republic, we had what we call the ICPC case, and the states were up in arms against the federal government regarding the ICPC, the enactment of the ICPC Establishment Act. And the states had gone to the Supreme Court saying it was within the remit of the state legislature to make those laws. But the Supreme Court held that this is one of those things that are Chapter 2 matters. So there are matters that fall within Chapter 2. And in the exclusive legislative list, I think it's item 57 or something. My memory does not serve me, in very opposite terms. But it provides that for matters that are under Chapter 2, the National Assembly has exclusive legislative competence. And I think that's AG Ondo versus AD Federation is a 2003 Supreme Court decision. And so on that basis, it's very clear that the enactment of the FCCPA has constitutional flavor, because when you look at section 16.2 and section 16.3, you're seeing how the National Assembly has now enacted that specific commission. So it begs to the question we have to always ponder about is that what about a Bofia, for instance, that has carved out the financial sector away from what is the economic justice framework that the Constitution is establishing in Chapter 2, and has given powers to the National Assembly to make powers for all parts of the Federation, right? So we need to sort of consider those things in how we think about it. So there's just the global roots of competition laws. We know where it started from the Sherman Act in the US. We know that there are veritable laws under the European Union. And we believe that, Section 16 and 17 of the Constitution are being operationalized by the enactment of the FCCPA. So there are 5 core objectives of the Act. But permit me to say that one of the things that is very important to understand is economic efficiency. Very important because it is a defense to all things anti-competitive. So it's very important, and it's a very economic term. But as lawyers, I think it's very important that we sort of understand how this plays. So efficiencies basically drive consumer welfare. And if you think about efficiencies, think about it as a ThinkPad. There are 3 types of efficiency. There's productive efficiency, meaning doing more with less. So it means ensuring that your production cost is at the barest minimum that it can be. That's a defense when you do something that is anti-competitive. Allocative efficiency means give society what it wants. It means that in society, if on this call, we have 2,000 guys on this webinar and we need 2,000 bottles of water, society demands that for a state of equilibrium, do not produce more, do not produce less. Because if you produce less, obviously, there will be an artificial scarcity. And as you know, when there's an artificial scarcity, if there's a glut in the market or there's scarcity, then you have a distortion. There are folks who are probably richer than some of us are here, and they can probably pay 2 or 3 times for a bottle of water than common folk like us can, manage. So you're going to have that thing where you're going to have a monopolist or a profiteering enterprise that will, use or utilize or exploit those circumstances. So produce, not more, in terms of productive efficiency, in terms of your cost effectiveness. Allocate means, do what is needed in terms of the numbers and output, not more, not less. Then the third one is dynamic. Dynamic just is technology and innovation helping over time to create conditions that promote welfare. So if someone was to bring a plant to Nigeria to ensure that there are less carbs in the rice that we eat and there are more protein, and the person can prove that over time it will cost people less to pay for a bag of that type of rice, and over time there will be significant health benefits. If the person was going to ask all the supermarkets to sell their things exclusively for a time and get into some arrangements, if you're able to prove and justify, this can be one of the bases for your action that can be considered anti-competitive to be justified. So that's how dynamic efficiency works. And think about it as a think pad. So PAD, right? Then we go to a framework for review. So again, as lawyers, I would like to say that I want you to, at times, take a leap away from analyzing text alone. I know that our basic duty day to day is to interpret text, either statutory text, contractual text, or case law, and you're applying it in one of many ways in different work products, either ending up as a brief before a judge or as advisory opinion or a memorandum to your client or to a regulator, or you're drafting an agreement or something, right? But you see, for competition law, you have to now wear the hat of a social scientist. And for social sciences, you're trying to observe how human beings behave. Remember, this whole thing is about human beings. What's the equilibrium? How is the demand side working? How are the guys in the supply side working? That's the essential question. And so the sort of evidence you provide, the sort of arguments you make, at the end of the day, all revolve around this very important social science conundrum. So you go at it, and in social sciences, if you've been in maybe a business administration class or if you've done anything in the social sciences, you know that there's always a framework. Unlike physical sciences, where things are more exact, with human beings, you have to have a framework. So it's either some tool, some framework, some model, like you can observe culture in an organization. So if you had the Hofstede sort of culture model, it's how people want to understand culture in big organizations or culture in a nation and things like that. Now, for competition law, the framework that regulators use over time worldwide and in Nigeria is what we call the SCP framework. And for me, it's easy to remember because, as you know, my firm is Simon Cooper Partners. So I'll never forget this. So SCP framework, stands for structural analysis first. Then there's a conduct assessment that is done, and there's a performance evaluation. So it means that before the commission would even undertake an investigation, is it worth my time to do so? So there's a structural analysis which tries to understand the markets, the market share, the players who are there. Is there concentration? If there's no concentration, it means that maybe I don't need to go into this. I remember concentration is a constitutional concept. So concentration is the sort of opposite or antithesis for competition, right? And so you want to determine these things before you go and find out how people are behaving in terms of pricing. Are they colluding? And are there sort of strategies around innovation within the market? Then you want to examine how they are performing. Are they profitable? Is there any efficiency, etc.? etc. So the framework is important to understand. And please permit me, this is just a primer. I can't do this in the time that I have. So I will be very fleeting, just so that you at least understand what the terms are. Then we have the relevant market definition. The relevant market definition is a very important thing to understand, because if you wanted to first maybe do an investigation about rice, around Christmas, you want to know what are the substitutes for rice. That's the social science inquiry that the commission engages in. Is there any substitute, for instance, for, let's say, Lasena rice, right? Is there any substitute for Lasena rice? Let's assume. And so the substitute for Lasena rice does not necessarily have to be other types of rice. It could be that the fundamental question would be that if you increased rice by 5 to 10%, so let's say rice was 1,000 naira and you added, let's say, 50 naira or 100 naira, would someone else go and buy pasta? Would someone else buy noodles? If people switch, then you know that that thing is a substitute. But if people do not switch, then you know that that thing is not in the relevant market, right? So commissions always like to define the relevant market in very narrow terms. Now, so there are two sides to the relevant market inquiry. There's a product market inquiry, which is what goods are functionally substitute. Is Coke a substitute for juice, for instance, right? Functionally, right? And how do you find this out? You have to ask consumers their preferences and things. So understand the social science sort of dimension of this. Then there's a geographic market element. And what's the geographic market element? It's for you to say some guy likes agege bread, but he lives in Mokola in Ibadan. And every day he gets on the train to come and buy agege bread in Lagos. He finishes, gets back on the train, and goes back. I'm sure you will say that that story is quite ludicrous. So it means that, in effect, the sort of relevant market for bread will have to be very local. So relevant market geographically can be nationwide in scope. It can even be worldwide in certain investigations. But in certain in things like staples, perishables, things that the bakery that is next door does, it becomes very local. So you've got to determine which area is in this inquiry. So you want to understand in your relevant market definition, which goods or services am I investigating, and in which area am I doing my investigation on. So this helps to narrow and give focus to the investigation. So there is something, as I've said, in social sciences, there's always a test, there's always a tool that is used. So we have the small but significant non-transitory increase in price. It's called the SNP test. Don't be too worried about all these technical terms. Once you get in, I'm sure you would understand them. And so the SNP test just does this in a way that you have a basis to test the market before you start a proper inquiry. Now, the relevant market issue is not an end in itself, it's just a means to an end, right? Then, obviously, market power. Market power simply means the ability of a firm to sort of raise prices, restrict output without losing customers. It means they can act independently of pressure, right? And it could be that you have high market share. It could be that there's a barrier to entry, for instance. It could be that there are very high capital requirements, for instance, to start a cement factory. If you don't have, like, let's say $2 billion, you can't. And there are maybe you can count the number of people that can raise that kind of money, right? It means that you've got to look at that. You've got to look at, are there barriers to entry in terms of licensing? Is it very difficult to do that? Then is there a lack of discipline from the other side of the market, right? So that's how you look at market power. Now, the next thing to know, these are just economic concepts that I'm reeling is what you call the Effendal-Hirschman Index. It's HHI. Again, don't be scared. It's just a sort of big word for something that is constitutional. We want to understand how do you measure market concentration and why it's important to do it because for the commission, for instance, if a market isn't concentrated, and I would like to just have you visualize how this works. What is important is concentration is on a spectrum, right? To the rightmost part of it is a concentrated market. To the leftmost side of my arm is a competitive market. If you look at this, the vastness of this, we're looking at something from 0 to 10,000. Why do I use those numbers as a measure? Because if someone had your monopolist, your hypothetical monopolist who has 100%, so for instance, the disco in a region for grid power is a monopolist, and not because there are no functional substitutes, but if you define your relevant market as grid power and not solar power that possibly takes far more, economic cost to start, right? You would say, okay, grid power is maybe a niche market, relevant market by itself. And so your disco can be that party. So if that party has 100% market share, what you do is you multiply, you do a square of the market share. 100 times 100 gives you 10,000. But on the left side is the fragmented marketplace. And let's say it's a market for homogeneous goods, goods that are not easily differentiated. So let's say water, for instance. I mean, water is even very differentiated. Some people drink alkaline water, some people drink all kinds of different types of water. But for purposes of education and our illustration here, let's say that we just have water, table water. And in our community of 2,000 webinar seminars, right, we have 100 producers. Everybody is in a fragmented marketplace. If someone has 4% market share, another has 5% market share, someone has 10% market share. By the time you do 10 times 10, it gives you 100. 4 times 4 gives you 16. 3 times 3 gives you 9. When you have a fragmented marketplace, small market share, it's the numbers are very low. You add up 100 plus 16 plus 9 and plus 4. Someone that has 2% market share times 2 is 4. And if there are maybe 40 people that have that 2%, 4 times 40 is giving you what? It's still giving you 160, right? Whereas this person that has 100% has 10,000. So it gives you a sense that in that marketplace on my left side, if you do anyhow, you see anyhow, let me use the pidgin parlance. If you increase your prices, for instance, if you do not have productive efficiency in how you run, and in this water business, you go and hire a lawyer to be your hydro engineer because he is your in-law. That cost, you can't add it because if you add it onto your cost run, someone else will take your market share because people will switch to other producers. But imagine a concentrated market. People have no options, right? I can pass on the inefficiency of hiring my in-law, right? If there are only two producers or one producer. So we must always understand that the whole theory about this economic justice is allowing autonomy, the autonomy of the customer to buy what he wants from an option perspective, the autonomy of the commercial actors on the supply side to provide the best sort of quality without colluding to give outcomes that are not driven by how effective they are at selling what they sell. So concentration is a measure of that. It captures it from a structural point of view, right? And the sort of example I've given you about market shares, explains that. So typically, if something is above 2,500, it gives you a threshold for concern, right? If something is between 1,500 and 2,500, it gives you something that is moderately concentrated. But if something is below 1,500, like the market I described on my left side, It shows you that it's unconcentrated. And in this sort of instance, I don't think that the commission, except there are exceptional circumstances, would want to investigate that. So I permit me to now enter what we'll call the tripod of competition law. And I want you to remember these things as I explain them. In competition law, there are two main things to think about. On that supply side, the two things to think about is how the singular actor that has market power can by themselves, which is unilaterally, affect how the market plays out, right? That's condition one. Condition two is how two or more can agree or coordinate. And anyone who has read the classical Wealth of Nations book by Adam Smith will tell you that there's never two producers come together to discuss or to have a tea party. They are always talking about prices, right? And so, hence, you have the unilateral conduct where one person, because they have enough power, can act by themselves, and you have coordinated conduct where two or more agree to restrict competition, right? So the tripod gives us the three substantive areas of competition law. Now, the first is restrictive agreements. You will find this in Section 59 of the FCCPA. Under Section 59 of the FCCPA, there are things we call per se, that on the face of it, there are four major things that are prohibited. Two parties who are in a horizontal marketplace cannot discuss their prices. So you can't have um, 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 so let's say there's Lasena water and there is Eva water. They can't come together and discuss prices. It's completely, outlawed, right? The second thing is, if you remember from your secondary school economics, right, you have what you call the demand and supply curve, the elasticity of demand, right? And there are two sort of coefficients on the X and Y axis. You would have two main things. It is always P and Q. It is price and quantity. So the major parameters of competition law are what? Is price and quantity. So you can't discuss price and you can't discuss quantity. So you can't say, I will do 10 tons during Christmas period and you will do 5 tons. You cannot. I know that this is how our country is sustained by a cartel, OPEC, because we discuss our volumes. And if prices are getting too low on the international market, we can just decide to cut our production quota. Saudi Arabia will cut Iran, we will cut Venezuela. And when we cut, what it does is that it now creates an artificial scarcity and prices start to trend upwards. So that is what happens when you squeeze, you limit production. And OPEC can get away with it because it is a conspiracy. It's a coordination by sovereign nations that cannot be pleaded in municipal or in local domestic courts. So just understand that theory, and you say, okay, so you can't, so your clients cannot engage in trade association meetings where they are doing this in a normative form because it's just completely prohibited, right? Then you also can't, go and share markets. So you can't say, oh, you've got a good distribution network in the north. So why don't you stay in the north? I've got a good distribution, whatever, in the south. I'll stay here. And you can't also do what you call bid rigging. So this is when there are different lots, and you find it in construction contracts, 3 lots. I will bid poorly for lot A. I will increase my price. You increase your price for that so that you get lot A and I get lot B. You also can't do that, right? So that's restrictive agreements because two or more parties agree tacitly or implicitly or explicitly to not compete against each other. What we want on the supply side is rivalry, two fighting, always just boxing at each other with innovation, with prices. I'm going to win customers with just how, great my product is or my service is. And not for us to get, very close with ourselves, and we start having this conversation about, okay, why don't we just don't compete and we do stuff? And so that's really what restrictive agreement is about, and it's coordination, right? Then abuse of dominance is the second part. You find this in section 72, right? What does abuse of dominance mean? Now, being dominant, being that you are either 40% of market share and above, or you're in a position where the ease of entry isn't great, or you have great financial power. Any one of those things can make you dominant. Dominance by itself is not illegal, but as the famous quote from Spider-Man comes to us, to whom is given great power, there's great responsibility that beckons, right? Once you're in the privileged position of having 40% plus, there are several things that you can no longer do. If you did them, it becomes abusive. And you have to think about it in two ways. Exploitative. Exploitative deals with you dealing with consumers directly. So the unilateral conduct, singular one, that is abusive from an exploitative standpoint is excessive pricing. So when you price things highly. Now, there's a case I think everyone should read. Is a United Brands case. Is a case out of the European Union. Now, what's the theory of this case was? Is very simple. You have like the biggest banana aggregator in the world, United Brands. What did they do? They were pricing in certain markets. So if you went to the hospital, anybody who went to the hospital and was in one of three categories of people, if you are old, right? If you're recovering from an operation or a procedure in the hospital, or if you were like an infant, or they're just weaning you off from food. Now, in these three markets, banana lends itself to easy digestion. So it's the sort of bounce back food in hospitals. So in hospitals, that's what they will give you. In old people's homes, that's what they will give you. For kids, that's what they used to introduce, sort of solids to them because it's easily digestible and all. So in the supermarket, for every other person in the population, if you increase banana by 5 to 10% in our SSNIP definition, someone will say, oh, my fruit quota, I don't want to eat bananas. I'm going to eat mangoes, or I'm going to eat oranges. So in supermarkets, that sort of option can discipline how they price. But in the hospitals where bills are just given to people and there's no option apart from bananas, and these guys were the only ones supplying bananas, then excessive pricing was something that they actually did. So that's for exploitative, so directly. But the major one is exclusionary, because most of the effect of abuse of dominance is to exclude or to foreclose your competitor. So you do it by one of many ways. So like predatory pricing, for instance, is when you price below your production cost for a sustained period. So you're sacrificing your profits for a period of time such that other competitors, they basically become extinguished. So when you have taken them out of the market, you are now able to recoup because you're not going to excessively price that product. So when you excessively price the product, it pays off the sacrifice and you recoup far more than when you made the sacrifice. But it's always an after the event sort of assessment. So every other thing, essential facilities, issue, all of these things are foreclosure, they have foreclosure effect. So that's the way to think about abuse of dominance. Now, what about merger review? Now, merger review is this, so again, big words, ex ante, ex post regulation, is that ex ante is what happens before, ex post is what happens after. So for things around restrictive and dominant, some of it is after the event. You have to see it and analyze it. But this is the one that you must do a predictive analysis of how the market will happen. So everything we've spoken about in unilateral and in coordinated, we want to prevent it from mergers. So from a jurisdictional standpoint, if you're doing a merger where there is shareholding that will move above 50%, that by itself is the jure sort of control. It means that you would have to, if you scale above, I think 500 million, that's the floor, right? You would have to notify the commission and they will do the assessment. Now, in the assessment is basically to find out whether this will substantially prevent or lessen competition. Now, you can be doing something that is below 25%, or sorry, that is at 25%, between 25 and 50, and still have to notify. And that is because you have what you call material influence. If you look in your corporate law, if you look in CAMA, you will find that there are certain things that give, voting powers in the company, super majority. But if you have 25%, you can veto certain things. If they're going to amend your memorandum and articles, if you're going to, get into some certain types of, corporate activities, you would need supermajority to have them pass. So the threshold for that material influence is 25%, and that's for good reason. So that's a detailed sort of exposition that will need to be done. But basically, now you're looking at everything in that space. Is it easy to enter? So, for instance, when you say it's easy to enter, one of the best examples I give was like during COVID, some guys saw how personal hygiene products, just went up astronomically in price, and they were doing um, soda. They were selling soda, but everything that it took to sell these personal hygiene products like sanitizers, they had them. They had bottles, they had the fillers, they had the factory, and they could get sugar, which is what everybody uses. And when you sort of refine sugar, it basically becomes methanol and alcohol. And also they had everything, and they could easily switch, and they became the dominant sort of local producers of hand sanitizers during COVID. So that's an ease of sort of entry slash expansion example that you want to give when you're looking at this thing from all the tripod that I've mentioned, but more so for like a merger review. You just look at a bunch of things that Section 94 will provide, and I cannot go into like details here. So I want also this to be interactive and to take questions. So I'm going to be wrapping up my like substance and my sources, and just something like a call to arms. So I just want you to take a moment to think about tomorrow. And by tomorrow is a metaphor for how your practice would be, how your career would be. Um, let's embrace understanding. Let's embrace the idea of complex is not bad, so to say. The United States is like the most regulated country. Like there are laws for everything, and that's why lawyers in America, it's a vibrant sort of industry, right? So competition law, I can tell you, is not like it's easy in terms of the sort of mental capacity and the discipline that you require. There's a lot of economics in it. There's a lot of just understanding some complex economic concepts. But what it requires is just mastery and discipline. So, and I'm saying this for the young lawyers. What sort of career would you want to have? Do you want to stay ordinary Well, how would your tomorrow be? How would you be 10 years from now? How would you be 5 years from now? What would 2026 be like? So the choice is yours. This is an opportunity, and you can settle it and say, okay, I actually want to do competition law, right? So the seat for your future is vacant, right? And you've got to just step up and occupy it. And generally for the industry, right? There's just a thing where the industry has to be more strategic and not necessarily try and weaken regulations by making self-defeating sort of arguments, strike out this law, you earn a 10 million or a 15 million, and all sort of this sort of advisory work. So if they strike out a certain piece of law, so one of the things I can say is that from 2018 to 2025, 6, you can say that this competition law as a sort of discipline within the legal industry has done in revenue billions and billions. I mean, there was a fine of 110 million US dollars that was actually paid. Just imagine if you're the lawyers advising on how to either lessen that bill or how to sort of, you know, pay instrumentally or something. Just imagine what it is, right? But this defeatist sort of argument, we have to just reflect on how it works because constitutionally, we are also the ones who should uphold economic justice. And as I've explained, right? The balance is never balanced starting from the beginning of the transaction. And so that's why the law is a measure to sort of create the balance, impose certain obligations that makes the demand side and the supply side at least stay at some equilibrium. And as between the actors on the supply side, you guys are not talking. This condition of the supply side is that there's rivalry, there's competition. You guys are not cozy and trying to, put an undue weight on the demand side. So that's what we as lawyers are called to do, right? So there's a pipeline of gold that is in this industry. Imagine if everyone that was actually doing a merger had, lawyers with understanding doing this. Imagine the sort of dominance investigations that will be on the landscape in telecoms, in banking, in like the cement space, in aviation. Imagine the leniency applications when you find out that people have had trade meetings and they are talking in these trade meetings. Look at dawn raids, there are compliance audits, there's preventive advisory work. It's a multi-billion naira pipeline of sustained high-value legal and economic work. And so my thing is that for my firm, it's fine for us because we understand this thing very well, very well. But I guess there's a lawyer here who wants to hear this, who needs to hear this, who needs to have their mind made up that I'm not going to be that lazy lawyer who does Section 44 of the Constitution and that's where it ends. I'm that lawyer who would understand balance sheets. I'm that lawyer who would understand the economics of it. I'm that lawyer who would understand all of these tools and I'm able to sort of apply them, day to day. So I just want to challenge you and say, okay, so from week 1 to 10, read the act. Read section 16 again. Be sure for yourself about what I've said about section 16, sub 2 and sub 3 of the Constitution. Then read the act. Acquaint yourself with the tripod, those 3 things. Then go and read all the regulations. There are regulations for 2020 for merger review. There are regulations for 2022 for restrictive agreements and also for dominance, right? And leniency, and just sub rules here and there. And I also understand that, the commission is also, in the process of even releasing more for exemptions and setting guidelines, right? Acquaint yourself with them. Buy books around the economics of it. Justice Brandeis of the US Supreme Court, basically said that, listen, for competition law is 80% economics and 20% law. right? So you've got to just get yourself in that mold where you challenge yourself and just give yourself a 10-week time frame and read it. I would also say for my younger colleagues, like, the amount of time we spend on needless stuff on social media, right? You're just consuming stuff that won't necessarily, inure to your benefit. So you can use that time for micro learning. You can use that time to go audit a book. And I mean, if AI is your thing and you want it to maybe simplify it for you, that's your thing. And use the tools that you have to understand these things in the language that you can express yourself in. Then you start publishing to a LinkedIn thread, analyze, what the FCCPC is doing, whatever, they've set out to do. And so this is my sort of commitment to you guys, right? I'm giving you that the first 15 participants who would send me something on LinkedIn, I'll give them a 50-page FCCPA playbook. This is not available online. And you will maybe see some of my insights because we've somewhat helped as a firm to sort of build the architecture of the regulations, the law, its interpretation, etc. So I would and fast fingers, just send me. So the first 15 will get this. Act fast, then I would also, over this sort of Christmas to January, have a 15-minute call where I can, you know, just have a strategy discussion with you about what you want to do in terms of your personal study, the books that I think are available. Some of them are free, some of them you've got to pay for. And I can do that recommendation for you. And yeah, so don't wait. Take the first step. Mastery is there. And what I've just done is just to scrape the surface, just to introduce you to what is, I think, a very great area and discipline, of law. So I would now, at this point, open the forum up for discussions. And Dara and the other organizers, how do we do this with respect to like questions and interaction?
Okay, thank you so much for that insightful breakdown, Kim. From the comments, it does seem that you have sparked some form of interest amongst the attendees. So thank you so much. We have a number of questions coming in there in the Q&A section. But before we move into the Q&A, there have been a few questions from participants asking if the slides will be available after the session. And also participants also asking for your LinkedIn name because you mentioned LinkedIn. So I don't know if you want to just share that before we move into the question Q&A proper.
Yeah. So I think the LinkedIn will be put on the chat. Yeah. So I'm sure if you just put Ikemi Sekwena on LinkedIn, you'll probably find me there. I don't know that there are two Ikemi Sekwenas yet. So yeah. So a simple Google search, you'll find me.
And the slides, would they be able to get the slides?
Yes, we'll make the slide. So the slide will be, so different from the FCCPA playbook that we will share. So that's, so we'll share the slides.
Okay, so the attendance link has been posted in the Q&A box, so please fill in this form. Thank you. So I'm going to go into the question. So the first question we have, it says that we all know that the constitutional provisions for economic justice is well-intentioned and designed for the common good. But the question has always been the practical implementation. How effective is FCCPC in the discharge of this constitutional responsibility, given our long history of political interference in the operation of government agencies and regulators?
Okay, so should we cluster like the questions so that I can?
Okay, so we can cluster the questions. The second question is relating to the merger control regime. So the question is it not counterproductive that the threshold is not too small? And is it appropriate for the FCCPC to charge a percentage of transaction as approval fees? Do you want me to add another question, or do you want us to pause here, Ikin?
Yeah. So just you can add one more question.
Okay, so I think one of them has been answered regarding what exactly is the specific role of a lawyer in competition. I think you have already addressed that question. And then how is the Manufacturers Association of Nigeria aligned with the aims of competition law in Nigeria? So I think I'll pause here for now. So the question is, how does MAN align with what the role of competition law is in Nigeria?
Yeah, I didn't get that.
Okay, so the person's question is regarding Manufacturers Association of Nigeria and asking how the role of MAN aligns with the aims of competition law in Nigeria.
Okay. So I would answer the questions in the order that you have asked them. So first was the question about economic justice and whether it is aspirational. So my view of this is that you must always have like values, aspirations about how you want to run a fair system, a fair country. And that's what I think the framers of the Constitution were trying to do in terms of articulating what the economic sort of justice principles are, to say, okay, we don't want concentration. So we don't want if you guys just buying all the land, for instance, to do all the agriculture by themselves and charge what they want, right? And so that's why we want a competitive sort of enterprising free market economy, right? Now, it is debatable whether at all times you're able to match, your sort of um, reality and what you're doing on a day-to-day basis with the aspirations you've set out for yourself. But I think it's quite commendable that at least you have a law that has now sort of stepped down that from an aspirational, non-justiciable, sort of in the air, lofty ideals into actual framework of laws. And what you'll find from 2018 is a progressive development. So the subsidiary legislative instruments that flesh out, that explicate what will happen in the sort of different circumstances, the adjectival framework of how things are explained and will be done, the procedural and processual things are all coming together. And you would also find now there's now just also boots on the ground, because what you're going to find in the competition law space is that because it is economic injustice, most times the fines are also sort of massive. Anyone can remember, I mean, my own sort of first incursion into competition law was with Mr. Bill Gates case and the Microsoft case. I mean, just sparked my interest, and this was in the early 90s and all and the matter went to court, and just following that was my own sort of interest in just being a competition law lawyer, right? So the fines in that case were massive, right? The fines that the EU imposed on Microsoft for using Microsoft Media and placing it just in the computers, right? Having OEMs just place them was considered an abuse of dominance, right? And that you will find is the EU expressing how it takes a dim view of abuse of dominance. Historically, and I'm saying is that historically, restrictive agreement was what was considered like a cardinal sin in competition law generally. But you've seen the policy, the aspirations in the EU taking a dim view more of, and this goes back to people's economic backgrounds. There's the Chicago school and the sort of liberal school and what that entails, but this is not the forum for that. So I would answer that, yeah, it's no longer baby steps. It's real tactile, tangible steps that this whole thing about economic justice, this whole thing about equilibrium, yes, for real, it's here. We can either contribute to the development or we erode it by, what I find very self-defeating arguments that are made, by lawyers. I think lawyers should be far more strategic in seeing just, that the arguments are just really just don't make sense. Like the argument that it's only courts that can, prescribe fines. How so, so something is coming into your airspace. You've got to, do a criminal conviction that takes people into the court system before you can stop that. Or the CBN cannot do something to stem use in its monetary policy system. It's just really, interesting, the sort of arguments that are made and that are made constitutional under Section 36 and stuff like that. So for me, that's what's important, for you to sort of have that mindset as a lawyer, that the aspiration is no longer aspirational, is here. And, is to sort of ride the wave of what is burgeoning and emerging, right? Then there was a question around major fees, right? So this is my personal opinion. My personal opinion, I think that thresholds are very important because not everything is substantive. Not everything will, because resources are not limitless. So you must make a decision about the things that really impact your economy as things you want to see. So we all know what devaluation has been in the past number of years. So maybe when the commission started with the thresholds that it had relative to like the dollar terms, it might have been something because it was really more or less taking what the SEC was doing under the ISA, the Securities and Exchange Commission under the ISA, that they just continue to do. But there's more stock to say now. Well, things have changed. Just a couple million or $1 million, you're looking at deals that someone's revenue is $1 million. There are mom and pop stores who do that sort of number. So there's obviously an argument to look at, should the thresholds be higher, but I'm not the regulator. I'm just proffering what my view is that the objective of having threshold is to catch the things that are important and not necessarily to catch everything, right? Then the question of the fees is also an open thing. I think it was more of an adopting what the SEC was doing at the time, and maybe that's the practice. But I also know that in other jurisdictions, major fees are relatively not necessarily cheap events because they take into account, the time that will be spent to analyze this in a wholesome way. So you will find that even in the US, for large measures, there's a sort of component of how, when it's this size, the fees that you pay to the FCC there and the US DOJ, it's different. So it's for us to think about it in that sort of fundamental way, and maybe the commission can see some light in a middle ground, but really that's really entirely within the commission's purview to do. Then there was one more question about the Manufacturers Association of Nigeria. Interesting question, and I say so because what I see that question and its sort of correlation with competition law is just that if you're advising any trade association or advising any bodies, and even for us, even as lawyers, when we're doing our MBA things, and we're doing scale of charges and all of this, we've got to be careful that we're not flouting the law, because really at the end of the day, it's a commercial service that we provide. And if we say, oh, you can't charge less than 500 K here, you can't do this, you can't do that. And you're doing it by an order. If you're putting it in very plain terms against what the law says, you're skirting around, like unlawful and all of that. So my thing is really more about if the Manufacturers Association of Nigeria can also, from an advocacy standpoint, say for the associations where people will gather together in the same sort of horizontal space. If you sell sugar, if you sell a commodity, same, and you will have an association, ensure that when you get in there, you're not discussing any of the four things or three things at a time. Discuss price, don't discuss quantity, don't discuss market allocation, and all. So that's it. So are there any more questions to take?
Yes, there are. Thank you so much, Ikem. So I'm just going to read out the next couple of questions. Just give me a moment, please. Okay, so the next question is, competition regulations and laws like the FCCPA are addressing what are obviously symptoms of a much deeper problem. They don't address the more fundamental issues, which are unreasonable regulations that act as barriers to market entry. And these regulations tend mostly to infringe on human rights of persons to association and expression. So I think this question is really asking about the link between human rights and competition law, and to see if there's a link between those two. So that's the first question. Then the other question is, this person is saying that there's little conversation and focus on, well, same thing, the human rights implications of these laws, then the greater need to address the more fundamental realities that make anti-competition activities more possible. And also the person is also asking about the way to empower the public to basically understand the concept of competition law. So beyond us as legal practitioners, what steps can we take to empower the public as well about competition law principles? So do you want me to go ahead?
So I can address, because these two questions are maybe more or less in the same sort of bracket, and
Okay.
I can just spend maybe 1 minute on it. So
Okay.
again, let's understand that for us, we are practitioners, right? And my remit today is to just sort of do a teaser. The eggheads who will go into like the details and all of that, will do their work. But what we need to understand here is there's a constitutional sort of source for what competition law does. And you as a lawyer, if you understood that framework, it makes your work, sort of easier. Now, the idea I try to, portray from just a first principle standpoint, just understanding the first principles, understand the idea of the equilibrium, understand how it is that every one of us use products, right? And so how does the market operate? And so the fact is that the whole human rights element, consumer rights, is actually a very fundamental aspect, because we use products every day. It might not sound like it's very sophisticated or anything, but we're using products every day. There's none of us who's in this webinar who hasn't used at least maybe 5 to 10 products and even more, right? So if there's a breach of your right in every sort of gateway, if what you're drinking, you can't sort of understand what it is, if what you're drinking is actually killing you, right? If you're buying stuff that is overpriced, if you're, I mean, a number of infractions that, so that's why you have the laws. The laws are saying, oh, beyond just what common law would establish as normative, we're actually codifying this to say, if you are a producer on the supply side, this is your relationship. You have all the information. And if you're going to breach any of your information sort of obligations, then you have part 15 of the law kicking. So all the things about representation, labeling, and all that, and the consumer rights and the duties of producers are codified. Now, on the supply side, how you interact with your fellow competitors, not to strong arm them, to foreclose them from reaching the demand side, and also not to get cozy with them and conniving to shaft the demand side. For me, is the essence of economic justice. So you can either want to take it as a human rights issue, but it's not necessarily classified as that under, our chapter 4 rights. But that's just my thinking around that issue.
Right. Thank you very much, Ikem. So there's a question regarding price. Just give me one moment to get the question back up. What are your thoughts about the price reality in Nigeria and parts of Africa, where prices go up and never come down? What are the sort of competition policies regarding that? Or is it a competition problem or more of an economic input problem?
Well, again, first principles, again, I always like to think about first principles. First principles just tell us that the reality of enterprise, commerce is autonomy, so the idea of having autonomous decision makers. If you're a consumer, you're making the best decision with your naira for the best sort of product that it can buy, right? If you are a producer, you are acting autonomously by yourself to offer the very best, right? Now, pricing, it's not something that ought to be regulated, which is why the law itself, the FCCPA, outlaws price regulation. So, it creates a regime where it's only when there is an anomaly in the market and for a specified period of time can the president, acting after the commission has done a detailed study, you know, constrain prices in that sense. So pricing must be this autonomous sort of, that's why it's important to have the mechanics in place to ensure that actors behave in the way that, they are pricing their products in a fair manner and, are not necessarily, trying to make monopolist profits, because of exogenous sort of circumstances. So pricing is not something that should be regulated. It's something that the market should do actually, but the idea that markets behave themselves, that the invisible hand that Adam Smith spoke about, happens, there's always the puppet master, there's always that. So which is what 100 more and more years of competition law being in existence are saying. The Sherman Act in the US was to deal with the trust issues and Rockefeller, etc., and what that dealt with. Then in the 50s, you had the great leap and the great work that the EU has done in sort of solidifying the jurisdiction, the jurisprudence. Then you have just over 120 countries that have established competition laws because, we cannot necessarily leave the markets to the independent sort of invisible hand, that just ensures that demand and supply operates willy-nilly. There's just always something that does not necessarily produce that sort of outcome.
Thank you very much, Ikem. So just to mention, just housekeeping. So the form for the CPD points has been pasted in the link. I've seen some comments saying that we're not able to access the link. If you're not able to click on the link, please copy and paste that link and paste it in your browser, and that should work. But I can see that a number of people have also filled it. But if it did not work on your end, please copy and paste and put it in your browser, and that should work. Thank you. So Ikem, there's a question regarding prosecution. So who commences prosecution for breach of competition law? And are there crimes or torts? So that's the first question. Then the second one is, are there any form of business or professional services that are exempt from competition law? Or does it apply to every business and every sector within Nigeria?
Okay. Yeah, so I think the first question was with respect to the liability framework in the Act. So under the Act, I would say that there is a criminal liability framework where actually for most of the contravention therein, there's liability, there are fines, and typically there will be a 10% of your revenue in the year of its occurrence. There's also like personal directors, and even actors within the enterprise, the undertaking, and how that, affects them from a personal standpoint. But there's also the administrative framework where the commission can undertake in a civil sort of proceedings where it does an investigation, then it makes a decision based on that, and it can impose fines, and it has a raft of measures to sort of have that implemented. And there's also the inherent sort of rights people have to go to court to contest things, right? Rather than have a complaint that is routed through the commission. Yeah, so I think that there's like private sort of litigation rights that parties can exert. What I can tell you is that a lot more needs to be done with our jurisprudence, sort of the economic analysis, our judges understanding this space better. There's a tribunal that handles this issue, as a matter of first instance before it goes to the Court of Appeal and the Supreme Court. So as the bar, we should actually even strengthen that sort of architecture so that everybody just sort of understands what needs to go in economic analysis, evidence taking when you're looking at switching behavior, substitution, and all the other things. So yes, was there another question in this series that I missed? Okay, yes. So the other question was with respect to whether professions or that are exempted.
Yes.
Now, the law allows for exemptions, right? But they must be invoked, right? And there is actually a framework that is coming out that can either be sort of general, benign. If this happens to you, you are probably exempt. While there are things that you need to specifically go to get an exemption, from the commission for. So, and the law also recognizes that professions can come, and if they're exempted, they are sort of exempt, right? But I think the engagement will need to occur so that there's that exemption that is legally binding.
Okay, thank you, Kim. So I think this is the final question. So this question is regarding it's the competition regulator, so that's the FCCPC, plays some roles similar to those of the Consumer Protection Agency. Is there any cooperation between these agencies or friction? So I think maybe it might be sort of useful to explain the evolution of the CPC to the FCCPC and then also the consumer protection agencies within the states as well, just to gain some clarity on this.
Okay. So very important question, especially with respect to the states. But from a progression standpoint, What I can say is that we used to have, so I think it was in 1992 that we had the first expression of the Consumer Protection Council decree in Babangida's time that obviously became an act when, we put down the khaki and we put on the Agbada in 1999. And it journeyed up until 2018 when there was now a measure of function that took on the competition aspect and the consumer protection aspect and fused it into one legislation and one regulator, right? So as it is in many countries, like in Australia, like in, Canada, South Africa, some of this Commonwealth, we now have like a fused regulator who does both competition and consumer protection functions as one authority, right? Then you have state laws because I think under the old laws, it permitted for, like committees or councils or something that I called it at the state level. Now, this is my philosophical interpretation and constitutional interpretation. If we look at section 16 and 17 as a chapter 2 matter, and if we look at what the Supreme Court has said in the AG Ondo State in 2003 and the AG Federation case, which sort of enabled the ICPC to operate, then it means that the states do not necessarily have the remit to have these sort of consumer protection things that are separate from the federation, But I know that some states have them nonetheless, like Lagos State, for instance. But it's just my own interpretation of the law as it is. Thank you.
All right, thank you so much, Ikem. I think those are all the questions that we have for today. So I think that we can wrap up now. So thank you very much, Ikem, for an insightful session. And I'd like to say a very huge thank you to everyone who joined us today, to the Leonard Silks, our senior colleagues, distinguished colleagues, ladies and gentlemen. We're truly grateful for your time, for how engaging you have been throughout the session. Our appreciation also goes to the ICLE for their support. If you have any more questions, please feel free to reach out to Ikem on LinkedIn. We trust that today's discussions has really deepened your understanding of Nigeria's competition law framework and its relevance to our profession as lawyers. Simasco will be hosting additional sessions in the coming weeks and months just to discuss other important aspects of competition law in greater depth. And so we look forward to hosting you again for this webinar. Before we close, please remember to complete the attendance form to ensure you receive your CPD credit. It's very important. And thank you once again for your time and participation. Please enjoy the rest of your day. Thank you again.
Cheers, everyone. Merry Christmas.
Thank you very much.